Welcome to Control and the Law, the podcast about coercive control and stalking from a legal perspective. Today we are discussing how stalkers, former intimate partners, and even friends and family members are misusing the civil courts in England and Wales to harass and stalk their victims. I'm Sarah Ellis, Barrister, and I'm joined by Claire Waxman OBE, Independent Victims Commissioner for London and the new Victims Commissioner for England and Wales from January. Claire has been Victims Commissioner for London since 2017 and has undertaken an ambitious programme of work to transform the criminal justice system to provide a better experience for victims of crime. Claire has also been the victim of a sustained stalking campaign herself, including being stalked through the courts. My second guest is Rachel Horman-Brown, Honorary King's Counsel. Rachel is a solicitor and the head of the family department at Watson Ramsbottom Solicitors, and she specialises in domestic abuse, stalking and coercive control. She is also the chair of Paladin, the National Stalking Advocacy Service, and Rachel was involved in the campaign to criminalise coercively controlling behaviour and advises the government and police regularly on these issues. So welcome to you both. And let's start by explaining to any listeners who don't know what the civil courts are. What do we mean by civil courts and what type of cases do they deal with? So, Rachel, can you explain this?
Yes, the civil courts are generally dealing with cases between individuals as opposed to the criminal courts where individuals are prosecuted by the state. And in the criminal court, the aim is to punish the offender for a wrongdoing. In the civil court, the main aim is to obtain financial redress for the victim. So they are very, very different. Generally speaking, you can't be sent to prison as a punishment in the civil court unless you fall foul of contempt of court, etc., which is another issue. The types of cases that the civil court deal with are things like personal injury, contract disputes, defamation, and some protection orders as well.
And if we can turn now to the scale of the issue, because the three of us, we all wanted to participate in this podcast, didn't we? Because we know that this is happening in our civil courts. We know that whether it's professionally or it's personal knowledge, anecdotal, and nobody's really talking about it, certainly not publicly. It's widely under-recognised by professionals. And Claire, as the Victims Commissioner for London, you've got constituents who are presumably reporting this to you, complaining about their victimisation through the civil courts. So as far as you're aware, is anybody actually counting this? Is there any research being done on it? Is the MOJ aware of it? Who's counting this?
So I don't think that the Ministry of Justice are fully aware of the scale of this, and I don't think any of us are really. I obviously became aware of it over the years through my own personal experience. My stalker took me to the civil courts on a number of occasions, and I actually had to take legal action against the Crown Prosecution Service for a failure to really uphold my human rights, because my stalker was claiming it was his human right to be able to access the civil courts. And so I actually thought it was just an issue that I had experienced only. And then over the years, it's come to light that many more victims and victims of stalking and coercive control were experiencing this. And I would say in the last 2 years, we have seen a real uptick. So there's a prevalence, I would say now, that most stalking cases that we see coming to our attention through our office in the Victims Commissioner London office, but also those who are supporting victims, so the Susie Lamplugh Trust or Paladin, are also seeing the use of civil courts in stalking cases. So I would say it is prevalent that stalkers are accessing those civil courts, and they can easily bring forward unmeritorious and vexatious claims that can look plausible on paper, but the victim, the stalking victim, has to then engage with their stalker through the civil courts. And that creates that link and that unwanted contact that the stalker is desperately searching for.
And that's, I think, one of the things we do need to acknowledge is how difficult it is for victims, because the legal system, it is a process, it is a procedure. And if somebody commences a claim against you, you have to engage, because if you don't, the consequences can be enormously damaging for individuals. So what we're talking about largely is money claims. So it's a claim for, perhaps there may well be a argument that there was a loan that hasn't been repaid, or there's been personal possessions that have been thrown away or something and need to be returned, or damages paid in lieu of being returned. And for victims, if they don't engage in that process, they can easily end up with a county court judgment. And Rachel, there can be terrible consequences that flow from that, can't there?
Yes, absolutely. I think it's extremely stressful for victims to have to deal with this because, like you say, it's not something that you can just ignore. And I agree completely with Claire. I have seen a huge increase in victims. Almost it's become the norm that when you speak to somebody who is experiencing post-separation abuse or stalking, that they are also experiencing this as a tactic from the stalker, because it immediately forces the victim to become engaged with the perpetrator. If you ignore the claim that's been issued against you, then the perpetrator will obtain judgment against you, which means they win the case, and they can be eligible for damages in relation to whatever they are claiming against you, whether that be for distress or, like you say, monetary value of possessions, etc. But in addition to that, they can also claim legal costs. So if they have managed to engage a solicitor and possibly a barrister in this, they can make a claim for their legal costs to be paid by the victim. So very quickly, those costs can be in the tens of thousands of pounds. So you have to then engage with it. And, potentially there are court hearings on the horizon where the perpetrator will be trying to manufacture an opportunity to be in the same room as the victim. So you have to then attend a court hearing, potentially wait in the waiting room opposite your perpetrator, go into the courtroom and potentially speak in front of the perpetrator. Now, when you are being stalked, that's an extremely stressful thing to do. And really, there's no alternative to being dragged into this situation. So it is a very effective tactic by stalkers. And there needs to be more done to recognise that and protect victims from this.
I think as legal professionals, sometimes we can underestimate how stressful and frightening attending court is for victims of stalkers or controlling ex-partners. When I did my master's, I did a piece of research about special measures in the family courts, and what that elicited was the fear of victims of coercive control. Not so much when they're in court, because the courts, I think, seem to now manage that better in terms of screens and separate waiting areas and vulnerable witness suites and things like that. But it was more around getting to court and what happened immediately outside the building, of course, which the court staff have no jurisdiction over. And that possibility of bumping into your stalker or your ex-partner outside the court building or on the bus on the way to the court is terrifying for many victims.
Absolutely. I mean, it's a huge concern and fear for victims if they have to attend the criminal courts to give evidence, but it's also a huge fear attending any court where your abuser is going to be there through family court, if it's family courts or civil courts. It heightens the anxiety and the concern around your safety. As you say, special measures is very much focused on once you're in the court, although in the civil courts, I don't think we have the protection needed in the sense of special measures that you get in the Crown Court or the family court that you can now access. So there's a vulnerability for the victim, especially when they're leaving court, because many perpetrators will use that court appearance as a way, and we've had victims be followed after court. And so it is a real safety concern as well, not just being in the courtroom, but attending.
Could I just add to that? I've had a number of cases where I have had victims assaulted by the perpetrator on the way to court, because that is the opportunity then when the perpetrator knows exactly where the victim is going to be. So we advise victims, change your normal timetable of events, etc., do things differently, start work at a different time, park in a different place. But on that day, your perpetrator knows exactly where you're going to be, probably how are you going to have to get to court, for example, on the same train or bus, And the other issue I find is the quality of special measures varies vastly from one court to another. And some courts provide quite good special measures, and in other courts, those special measures are just not up to scratch. So I think more focus is needed completely on this area.
I think with special measures and the courts, one of the difficulties is the court estate. It's old, and there are a lot of buildings that are not suitable as courts, that are being used as courts. And so that provides limitation, because certainly in the research that I did, there were two things that were particularly helpful. One was having separate entrance and exits. And there are some courts that there aren't. Everybody, including judges, have to go through the same entrance and exit. And also staggering the times for the claimant and defendant, controlling person, victim to enter, particularly to enter the court. Because when you're in court, the judge can keep one of you behind and let the other one go. But if you have a staggered entry time, that at least means that the controlling person stroke stalker, if they do turn up at the same time as the victim, there is an intentionality about that which can be brought to the judge's attention, and it should give some reassurance to the victim.
I was just going to say, I mean, look, we need to be using technology far better. I mean, the technology is not great in the courts. We have, obviously, as part of special measures, we also have Section 28, which allows for the pre-recording cross-examination, but it doesn't work particularly well in practice due to the issues with technology, and the same often with live links. But that's absolutely where we should be going more towards if we want to ensure the safety of victims and witnesses coming to court. We can give a live link so they don't actually have to come into the physical court building. I also take away some of the anxiety and distress as well, not just travelling in, but coming into a court building. We've got a paper being published next week all about the court experience and how we can improve the victim's confidence in coming into a courtroom and being cross-examined. Because for many victims, they've never spoken publicly before, even the very basics. So not only are they trying to navigate that fear, anxiety, and trauma about coming into court, seeing their stalker, but they've also got to speak publicly and be questioned. And it's a very uncomfortable environment for many victims. So there are better ways that we can be doing this.
If we just turn to the nature of the issue, because there is some complexity to this, isn't there? Because we have a variety of cohorts of victims and perpetrators here. So we have perhaps what we can describe as stranger stalkers. So those are stalkers who are stalking people who are complete strangers, whether they be celebrities, which I think, Claire, you've had experience of in your work as Victims Commissioner in London, or even, and it can be as ordinary as the Amazon delivery driver takes a shine to somebody he delivers a parcel to. But it's still a stranger. Then we have the former intimate partner abuse, which I would describe as post-separation abuse. And then we have friends and families, disgruntled friends and family, who also pursue their victims through the courts as well. And that would be non-stranger stalkers. Now, Claire, in your work as the Victims Commissioner for London, what sort of numbers, what sort of breakdown of numbers are we talking about for this victimisation?
So we published the London Stalking Review back in 2024, summer of 2024. And what we did was we looked at Met data, but this is reported cases to the Met Police. We looked at a certain period of time. Most victims were women aged 25 to 44, but there's a huge amount of underreporting amongst men as well, minoritized communities. We saw in the London Stalking Review, I would say more cases fell into that ex-intimate partner than they did in the sort of stranger stalkers cohort. But we know from wider research, and I know the research that Susie Lampley Trust has done over the years, that it's sort of often a 50-50 split between ex-intimate and non, sort of what we call non-DA stalking, which covers the rest of it. But what we see is, I think we've seen a prevalence of those that are being taken through the civil courts are often those that they are somewhat more strange, or they're not people that they know particularly well. taking them through the civil courts. And as you've said about celebrities, we actually have had some high profile people come to us where they've never heard of this person before, and yet they've got a civil claim against them. And then it's come to light that this stalker has actually brought civil claims against other people many, many, many times before. And the concern is, though, it's never identified by the civil courts or picked up in any way. And I think that's a big concern. The government's talking about backlogs in our courts, the lack of resources that we have within our courts. And I think this is a big area for them to look at, how our civil courts are being exploited and abused. Actually, all our courts, because even in the family courts and our criminal courts, we see stalkers exploiting and abusing legal proceedings in order to continue that unwanted contact and to frustrate and to impact the victim.
And Rachel, you've represented a number of victims of stalking and post-separation abuse, and then I understand have become the subject of that either personally or your firm has. Is that something you're able to share?
Yes, I think we've had a number of perpetrators of coercive control or stalking who have turned on to the solicitors dealing with the case, the solicitor defending the victim, if you like, that the stalker has focused on them as the person standing in between them and their ultimate victims. Their thinking process, I assume, is that if they can make it very uncomfortable for that professional to continue to represent the victim, then the victim becomes all the more vulnerable and defenseless, if you like, to the perpetrator. So it's very common that you'll get things like vexatious complaints made to the SRA, the Solicitors Regulatory Authority, for example, or the Law Society, or whatever they are able to utilise, depending on the profession of the individual defending the victim. And we've had a number of cases. I myself have had several cases where I've been sued personally by stalkers as well, even though all I have done is represent the victim within proceedings or just giving advice to a victim. So it's really a way, in my view, of isolating the victim further, really, from any form of help. And I've also seen perpetrators sue victims' family members, for example. Anybody standing up for the victim or showing any kind of support for the victim will be seen as fair game by the stalker. And their motive, really, is to isolate that victim. And the distress that causes to the victim, it really is horrendous.
And going back to what Claire was saying, stalkers are using this throughout the court process and abusing the courts in this way. At the heart of the issue, to some extent, is this assumption by professionals that obviously we live in a democratic society and we have strict legal rights that we are entitled to assert. But there is almost an assumption on the part of professionals that those legal rights are being asserted in a way that is reasonable and with good faith. And therefore, when you go to the police and you say, I'm being stalked in a particular way, I'm being taken to court unfairly, it's a civil matter. The civil courts will determine it. And there's nothing we can do. And yet we know that it's not true. It's not the case that these people are acting in good faith. What they are doing is they are using the courts, certainly in the case of post-separation abuse, rather than entrapping somebody in a relationship, they become entrapped in vexatious litigation. And certainly they can be for years, not just months, but for years, and particularly via the family courts. And that's becoming recognised as a thing now. So how do we balance the legal rights of perpetrators with trying to protect victims from vexatious litigation? Claire, I know you've been working on this, haven't you?
It's a tricky one because I think we have to look at different scenarios. So I would say if we have a victim who it's already been proven that this person is a stalker, they've been convicted and they are subject to a restraining order, then I think we have a way in which we should be limiting, and we're not taking away their right, but we should be limiting their right and ability to access the civil courts. to bring claims. So what we can do is we can include that in protective orders like a restraining order or even a stalking protection order, where that stalker can only bring a civil claim, first of all, with the leave of a judge. So you have to bring it to the attention of the judge first. So therefore, you're safeguarding that victim being pulled into this vexatious, baseless claim and the whole process and having to fight it themselves, that a judge would look at it first to see if there was any merit in the claim. So I think we should be doing that much more than we currently do. Then we have the victims, and I would say this is a majority of the victims that contact us that have reported the stalking to the police. And as part of the stalking that they've reported, they're also being taken into the civil courts with these vexatious litigation. And the police, as you say, Sarah, often say, well, it's a civil matter. There's nothing we can do. But actually, I've worked very closely with the Met over the last few years to try and improve their understanding and awareness of stalking. And they do now recognise vexatious litigation as a form of stalking and a course of conduct. The issue that they have is they're quite powerless in the process. So whilst they're investigating, they can't help the victim in any way. So they are not an interested party in the civil courts. They can't ask to stay the proceedings on behalf of the victim whilst the investigation is ongoing. So we've got some issues there that we need to address. Can the police let the courts know that there's a live investigation into stalking, that we believe this is part of a stalking campaign against this person, and to stay the proceedings whilst the investigation is ongoing? The slight issue we have with that route, though, is that we know prosecution rates are not where they should be with stalking. So my concern is that if we see a case where there's no further action, we then leave that victim very vulnerable and open to continue to have to engage with their stalker through the civil court. So that's an issue. And then, of course, we've got the victims where they're just being taken into the civil courts. And I've got a victim that's been repeatedly taken into the civil courts. There's not been much else in the way of stalking behaviour, but it's still a form of stalking. So it's, trying to urge those people to report to the police, but they are very much left on their own with very little advice, legal support. Many can't afford for legal representation, so they have to try and navigate this themselves.
And it's important to note, isn't it? There's no legal aid available for victims of stalkers in the civil courts.
This is a huge problem for victims because in the family court, for example, some victims dependent on their means, and this is the minority of victims, but some victims are eligible for legal aid still. So at least that financial worry isn't there. But in the civil court, you can't access legal aid. So you either have to represent yourself, which means you're thrown into the lion's den completely, where you're having to correspond directly with the perpetrator, which obviously is a horrendous thought for most victims, or you have to engage lawyers. And civil justice is extremely expensive. In my view, it's more expensive even than the family court, and that is expensive enough. And the other problem is that whilst it is possible to obtain cost orders in the civil court against the loser, if you like, so if the perpetrator brings a vexatious claim and the judge eventually decides it was vexatious or at least without merit, then the judge can make a cost order and say that the perpetrator should pay the victim's legal costs. But that only works if the perpetrator has got financial means. So if the perpetrator doesn't have savings or a property without a mortgage, for example, or a very high income, then how are they going to pay that? How do you enforce that order? And actually, it costs more money. You've got to pay lawyers again to try and enforce the order. And the other thing I would say is that we do need to consider this as almost a standard term within a restraining order, because this is such a common tactic used by stalkers. So when we are looking at a non-molestation order or a domestic abuse protection order or a restraining order in the criminal court or civil court, we need to be thinking about, the standard terms such as not permitted to communicate with the victim, not permitted to go within 100 metres or whatever of somebody's address or place of work. There needs to be a standard order that they are not permitted to issue any civil claim against that victim without leave of the judge. And then that's highlighted to the judge at day one that this is potentially a vexatious claim, and that the judge needs to spend a little bit of time looking at the context.
A lot of legal professionals don't really understand coercive control or stalking, and therefore when it comes to evidencing it, they don't necessarily evidence it in the right way. And also this brings another central issue, which is there really isn't a huge downside to either stalkers or to controlling people to behave in this way, because what are the sanctions to them? They make false allegations to social services if it's a previously an intimate partner relationship with children. Frequently they make false allegations to social services because they are concerned the children are being neglected. They may make allegations that the victim has committed crime, often at their behest because they were being coercively controlled by the controlling person. They start claims in the civil courts. They do all sorts of things post-separation, and yet nothing happens to them in the vast majority of cases. And this is the difficulty for victims, is that they are victimized and the perpetrator just gets away with it because we're not in any way sanctioning what they do.
Yeah, I mean, I would agree with that. I mean, we only have to look at the sort of the low conviction rates for coercive control and even for stalking. So, this is a big issue. The stalking legislation, it came in 2012, and then coercive control, was it, Rachel, 2015, wasn't it?
15,
yeah. So,
yeah.
and I think it's been very slow over the years to implement these legislations well. And for the criminal justice system as a whole, not just the police, but the whole criminal justice system, to really understand stalking and coercive control. I mean, the London Stalking Review that we did last year, and actually the super complaint on stalking followed shortly afterwards, both made the same calls around the stalking legislation, that it's not fit for purpose and it needs to be reformed. So government have just appointed Richard Wright KC, who is doing a review of the legislation in the hope, I think, to make suggestions on where we reform it. And that should come to government early next year. And I think he'll be looking at coercive control as well, post-separation abuse, because of the overlap with stalking. And I've spoken to him in particular only just last week around the use of courts and vexatious litigation and how that's a form of stalking, to make him fully aware of what's going on, and how we might be able to reform the legislation to make it stronger, so that there are, as you say, Sarah, there are actual sanctions against these people who continue to manipulate and exploit our legal processes, and be it, as you say, even to social services, making these false claims all the time, which is to harm that victim and ruin their life, because that's why they're doing it. So it's to better recognise that.
Yeah, I agree with that completely. And I think coercive control and stalking, they are very similar behaviours often, and they are misunderstood by most professionals and most agencies, I would say. We always blame the police, but I think, this is an issue which affects, lots and lots of different people and agencies. But I would say the body at the bottom of the list of failure to understand coercive control and stalking is probably the civil courts. And, civil judges, I don't think this ever comes across their horizon. I don't think they ever consider this in a case. And this is something which, hopefully doing things like this podcast and starting to have this discussion will start to change things, because we all need to be aware of being used by the perpetrator, and the civil court will be used as a tool to oppress the victim and cause the victim distress. So it's important that we don't collude with perpetrators in this way, and that we are always on the lookout for this kind of thing.
Now, we know, if we now look at what can we do, particularly in the context of the civil courts, we know we have civil restraint orders. There are 3 different types of civil restraint order: a limited, extended, or a general CRO. Quite difficult to obtain. It requires at least 2 or more claims or applications which are deemed to be totally without merit by a judge. And also, there is a national register of these. I don't know if you know that. It's on the gov.uk website, because I had a look at it the other day. and it has a list of all of the CROs that have been made in the courts in England and Wales. What I would say is quite a short list, considering the number of civil claims there are every year. There aren't very many of them. And certainly in at least one case that I saw, it looked as if two different courts had made a civil restraint order against the same claimant. So the barrier to obtaining one appears to be quite high, and it's something certainly that could perhaps be reviewed and amended to make it easier to obtain. Do you agree with that?
Yeah, so when we had the Domestic Abuse Act, when it was a bill going through Parliament, we looked at and was very clear on how do we shut down some of this vexatious litigation. And so we put in for the better use of the barring orders so that, family court judges hopefully recognise, obviously there's training that needs to be undertaken, but to recognise when these proceedings were continuing and they were vexatious and they were just being done to obviously impact the victim. But we don't have anything similar in the civil courts. As you talked about, we've got the civil restraint orders, but the victim has to go through it at least twice before we can get a civil restraint order. I know that from my own experience. 3 times eventually we got a civil restraint order. So I know from firsthand how difficult that process is. I think we need to be looking at changing that. And I would say after one, if you've unfortunately, I'll have to go through one because, as you say, we don't know the facts of the case. It has to go into the civil courts, unless, of course, there is an investigation, there is wider evidence that shows other areas of stalking, other behaviours of stalking, or there's a restraining order or another protective order in place. I think those could be shut down immediately. But if it is just the first time and it's through the civil courts, obviously you're going to have to let that go the first time. But if it's a vexatious and it turns out that it was a baseless claim, then I don't see why you at least shut it down so you stop them ever bringing another claim against that particular person.
And again, in my own personal experience, I have a civil restraint order against a stalker, but it took 3 meritless claims, to be struck out until the court were prepared to make that. And I just think that that's way too long. And I agree that it's very often apparent at day one on the first claim that not only is this without merit, but it's part of a course of conduct, and that the context of it is coercive control or it is stalking. And I think that is so obvious, from one claim that it should be able to be made at that stage. I do have concerns about, there may be a register of these claims, but I'm not sure how effective that is in stopping them still slipping through the net. And this is the real problem, that it's no good having a civil restraint order if it's not picked up at the gatekeeping of the court when the perpetrator tries to issue another application. And I've seen a number of cases where, notwithstanding civil restraint orders, claims have been listed and victims have had claims served on them. There needs to be a better system put in place, both in the civil court and the family courts, the same issues really, in terms of both of those.
Now, if we again look at the civil courts specifically, and Claire, earlier you were talking about vulnerable witnesses and parties and special measures. We have Practice Direction 1A of the Civil Procedure Rules, which is specifically for vulnerable parties and witnesses, and that does provide for special measures. It also provides the whole emphasis of that is to enable parties to give the best evidence that they're able to give, and if there's a vulnerability, that the court has a duty to identify that vulnerability at the earliest opportunity with the assistance of the parties, and to then make consequential directions. And that can be in respect of how the hearing will take place, whether it will be remote, whether it will be in person, whether, as you said, Claire, there will be pre-recorded evidence given. All of those things are options in the civil court, at least theoretically. And also cross-examination. It can be that the court appoints, in effect, the QLR system, the qualified legal representative system in the family courts, that's now embedded and is used extensively. The court can appoint a legal representative to conduct cross-examination of a vulnerable witness or party, either on their behalf or against them. So that there are those possibilities. And in respect of the vulnerability of parties, it specifically refers to where there's been sexual assault or domestic abuse. There's no reason why being a victim of stalking couldn't be included explicitly as a character, as a vulnerability that the court should be concerned with. I don't know what your thoughts are, Rachel, about this, about amending PD1A of the CPR.
It's great that that is available, but it's only as good as the training and knowledge of the judge, isn't it? And my understanding is that civil judges don't really get any training on anything around coercive control or stalking. So I think, whilst it may be available, I would love to see the statistics as to how often this is actually utilised, how often this is requested. Are victims aware of it? Hopefully after this, yes, they will be. And how often is it granted? Because I've seen lots of cases where judges have refused requests for special measures. And that's why, this issue has been raised time and time again with the domestic abuse bill, etc., because judges weren't allowing, they weren't preventing cross-examination. They weren't providing proper special measures.
Yeah, just to echo what Rachel is saying, the big issue, though, in the civil courts, the victims that we've seen, is that they're not seen as a victim in the civil court. So they're the defendant. So they are struggling to access the special measures because one, it's not being recognised that they're being stalked, and two, their vulnerability is not being recognised. So they don't access the special measures. We've got one victim I can think of who tried to get a remote hearing, was so fearful to go into the civil courts with the person that was stalking her through making these vexatious claims, but it wasn't granted. So Rachel says they're only as good as their, if we're recognising it, the training is there and we're implementing it. So I think there's much more to be done around special measures in the civil courts, around understanding their need, wider than just rape and domestic abuse, but other vulnerabilities as well, especially around coercive control and stalking, but also recognising the way their courts are being used by the stalker to continue that harm and unwanted contact. And that needs training. And we've talked about the family courts for many years, and the Domestic Abuse Commissioner is doing brilliant work to really shine a light on the issues in the family court and why we need further training. But we need to be now really shining a light on the civil courts as well, and they need to get up to speed.
So if we just turn to advice for victims, because victims do need some advice. As Claire, you've said, they don't know the system. They don't know perhaps that there are special measures available to them. They don't know about Practice Direction 1A, which does specifically invite parties to identify vulnerabilities early on in the process. Claire, in respect of your office, as we've already established, there isn't legal aid available for victims of these sorts of proceedings. So what advice does your office give to victims who are facing this situation?
So if they are victims in London and they've come to our office, we will always try and encourage them to report to the Met Police. We have the Stalking Threat Assessment Centre within the Met, which is a centre of excellence, which is the police and the advocates from Susie Lampley Trust. And we also have health partners and probation all linked together, working together. So we would try and get them to report if they can. We would also try and advise them on what that process looks like in the civil courts. We're really stuck because we don't have, actually, poor Rachel's had to have quite a few come from our office because we don't know who else to refer these sorts of cases to, and because there's very few, I think, that have the expertise and understanding that Rachel has. And so that's a big gap, unfortunately. And so we just have to advise them on going to the police and also support services. So in London, we have the Susie Lampley Trust, the London Stalking Support Service. We would refer the victims there as well to get their advocacy and support. But it's very limited, unfortunately, because more often than not, we have to tell them they're going to have to navigate this legal process pretty much on their own. And it's incredibly difficult financially, emotionally, and that they've got to go through this process. So I would like to see this area properly looked at by government, by the Ministry of Justice, that we work towards putting in place mechanisms that stop these vexatious claims as early as possible, so we can protect the victims. We can also stop our courts being abused and used in this way. How precious court time is at the moment. We know what we're dealing with the backlog. So we really need to identify these cases much earlier. And we need better support pathways and guidance and information to victims who are going through being stalked through the civil court process. And I think that's lacking. We need to put together almost an information pack and pathway of what this looks like, what your rights are through this process. We have it with the Victims Code of Practice through the criminal courts, but we need something through the civil courts as well.
And Rachel, what would be your advice to victims?
In terms of what victims can do themselves, if you do get served with a claim, it's really important that you look at the time limits on these things, because in the civil court, if you are a day late or even a few hours late in filing your responses to various documents, then you can't proceed with your defence, and the perpetrator's claim is held to have won. So it's really important that you're aware straight away what the deadline are and that you diarise that properly. If you can get some advice, great. If not, then you're going to have to do your best to complete these documents yourself. When you come to complete your defence, which is one of the main documents you will have to fill out, it's really important that you flag this straight away to the judge that this is, in your view, part of a pattern of behaviour by the perpetrator, and that this is a tactic of stalking or coercive control, and perhaps give a little bit of context for the judge there. I would say in your defence, in your view, you are a vulnerable party by virtue of the fact that you are a victim of domestic abuse or stalking, and try and highlight that. Obviously mention the practice direction itself. It's practice direction A, so put that in your defence as well, because the judge might not have heard of it. And yes, the judge should have heard of it, but it's not unusual. And flag that up so that the judge can at least remind him or herself what that means, and hopefully start to treat your case in that way. And also flag up at day one that you want there to be consideration and potentially even a hearing about special measures, and what kind of special measures you need to think about, what you need, what special measures would make this easier for you, such as things we've talked about already, like remote hearings, that the proceedings are potentially transferred to your local court rather than the perpetrator's court. You can ask that there be a prohibition against cross-examination, so that the perpetrator isn't allowed to ask you questions. You need to think about how you're going to communicate, because if you're not represented by a solicitor, there's an expectation that the parties will email each other. So how's that going to work? And what I would recommend is, have somebody else deal with that if you can, or at least have a specific email address just for that. So it isn't constantly, when you go to log on to your emails, that's not constantly popping up in your inbox, and that you can kind of steel yourself ready to look at the litigation correspondence. And also, if that starts to become oppressive, then that's something that you need to raise with the judge as well.
And I think it's incredibly important that they do try and have the claim transferred to their own home court, because otherwise they could be travelling miles to the claimant's home court, which is the last thing they want to do. The only thing that I would add is that although we've been talking about stalking and post-separation abuse, and it's incredibly serious, they're not a defence to a claim. So when you do file your defence, you do have to address what the claim is against you from a legal perspective. So if they're saying there was a loan that they lent to you and you haven't repaid it, then you do need to address whether there ever was a loan or it was a gift, or whatever the circumstances are. So you have a legal defence, as well as obviously referring to your vulnerability as a party and seeking those special measures.
I think I just want to add that if someone is being stalked in this way, when you're reporting to the police, it's worth looking at. So one, if it's a civil claim that they're making, that's a vexatious basis civil claim, but also think about how was that communicated to you? Was it sent to you as court documents or emailed? Because the stalking legislation as it stands at the moment, you really just need 2 incidents to show a course of conduct. And I would say that, if you were sent emails and written to, and you've got this civil claim, that is your course of conduct. The police should therefore be investigating robustly and looking to build a case towards a stalking 4A charge, because you've got the 2 incidents, and obviously it's having an adverse impact on your life, and you can demonstrate that to the police, that you're changing your lifestyle in some way. That is the stalking 4A legislation.
I would agree with that, but I would say manage your expectations in terms of the police response to that, and it's certainly capable of being prosecuted in that way. But the reality in my experience is that most police forces probably won't do, unless more pressure is brought to them. So don't take their first kind of no as the answer. Keep pursuing it, keep complaining about it. And there is guidance issued around what these offences mean and the types of things that can be used as evidence in these cases. So it's all available on the internet. Have a look at it and make sure you know what that says before you speak to the police and complain.
And just to add on to that, sorry, Sarah, very quickly, the support services. So if you come into contact with whether it's Paladin or Susie Lampley Trust or even victim support, depending on where you are in the country, they should be able to advise you on that as well and provide some support and advocacy. And of course, any victim of crime, you have rights under the Victims Code of Practice. So make yourself aware of that, especially if the police come back and say, no, they're taking no further action, or if the CPS decide not to charge, you have a right to review that decision under the victim's right to review. So making sure you know what your rights are, so you're empowered as much as you can be.
Thank you very much to both of you for joining me today.